Hey there, I'm Louisiana estate planning attorney Paul Rabelais, and in this video we're going to explain the Louisiana Revocable Living Trust. Okay, let me give you a little bit of background. The traditional way that people leave their estate to their survivors is through a last will and testament. Most people understand the concept of will. Many people have a will. A lot of people say they need a will. So that's the traditional way people leave stuff to their survivors. You leave everything in your name. You leave your home in your name, all of your accounts. Everything you own, it stays in your name. And then in your will, you might list specific items that are destined to go to certain people. And then your will lists who receives the remainder of your estate, or who receives all of your estate if you made no specific distributions. But when you leave assets to your survivors through your will, I'll call your last will and testament your will. Your assets are going to be frozen when you pass away. No one can access them. Your survivors are required to hire attorneys like myself and go through what is known only in Louisiana as a succession. Most other states call this court-supervised procedure of transferring someone's assets via their will to the survivors. Most states call that a probate. We call it a succession. We're a little different. The way the succession works is the survivors hire a lawyer. The lawyer prepares various court pleadings. The heirs sign off on all of the pleadings, and those pleadings typically include a list of all of the assets and debts of the deceased, a proposed distribution of how those assets are supposed to be distributed pursuant to the will, or quite frankly, pursuant to the laws of Louisiana if the person who died had no will. And then the judge that's assigned to the succession proceeding approves the paperwork by signing various court orders throughout the process and ordering the transfer of assets from the estate of the person who died to the heirs. Having to go through a succession often justifiably gets a bad rap. Typical complaints about a succession include it takes too long. Some of them take several months, some of them take longer. Some of them take several years, particularly if people are questioning kind of the details that are involved. Other complaints, it's expensive. Every succession, lawyers must be hired. Yeah, there's some court fees, but most of the succession expense is the lawyer expense. And those lawyer expenses can vary primarily by the way you get charged from the attorney or the attorneys that are involved. Some of them may charge you on an hourly rate. They bill you for every minute or 10 minutes or 15 minutes that they work on your matter. Some of them may charge a percentage of the value of the estate, while other attorneys may charge just a fixed fee, and they let you know before you begin what that fixed fee will be to cover all of the matters related to the succession. And the fact that because of the time, expense, and often a lack of communication and transparency, the relationships of those that go through it get strained. Enter the Revocable Living Trust. Instead of leaving everything in your name to be frozen when you die, which requires you to hire lawyers to take the family through the court and attorney-involved succession procedure, you create what's called a Louisiana Revocable Living Trust. You transfer title of assets that would have to go through that succession when you pass away, like your home, like your real estate, like investment accounts, like business interests. You transfer those assets to your Revocable Living Trust while you are alive. You are the trustee of the trust, so you're in control of managing all of the trust assets. You are the beneficiary of the trust while you are alive. You can do whatever you want to with the trust assets. But the kicker is, when you die, see, things in a trust don't get frozen. They don't have to go through a succession. The beneficiaries of the trust don't have to hire lawyers and wait for judges to sign court orders. The successor trustee that you name in your Revocable Living Trust might be a family member, might be co-trustees. The successor trustee that you name in your Revocable Living Trust gets immediate access to distribute your trust assets to your trust beneficiaries that you named when you established your trust. Thus, when someone creates a trust and transfers their quote-unquote probate assets to their trust, the succession procedure, along with its delays, expenses, and hassles, are eliminated. All right, that's a quickie view of really just intro to revocable living trusts in Louisiana. I'll have a lot more to say on that. Make sure you subscribe to the channel. Feel free to like, comment, contribute, and we'll see you next time.